Hi everyone, thank you for joining today's ITCC member meeting for September. So for today's meeting, I have a few announcements and then we will get into our presentation. It is the challenges in GDPR compliance for international certification programs and preparing for other privacy regulations waiting in the wings. This will be presented by Robert Pryor, Director of Corporate Compliance and Security for PSI Services, as well as Marc Weinstein, Chief Privacy Officer and Vice President of Investigative Services with Caveon. So going into our announcements, we will have an election during our in-person meeting. This election is for the chair position, which will run from 2019 through 2020. There will also be a vote of confidence for the vice chair and secretary/treasurer positions. We will be sending out ballots on Monday, October 8th, and then voting will close Monday, October 15th at 11:59 p.m. Central Time. Those ballots will be electronic. And don't forget to save the date for our in-person fall meeting taking place October 15th and 16th in San Ramon, California. Thank you again for SAP for hosting. Here is a look at the full agenda in case you haven't had a chance to look. We do want to point out we do have a member case study with Google on Monday, as well as a Solve Your Problem session. We also have our member networking dinner that evening. And then on Tuesday, we have another member case study, this one by Scaled Agile. And we will wrap up the day with another Solve Your Problem session. Here is our current task force schedule. If anyone is interested in joining other task forces, please feel free to email info@itcertcouncil.org and we would be happy to get you the calendar invite and any pertinent information for that task force. So with that, I will move the call over to our presenters.
Hi, this is Marc Weinstein with Caveon. Want to make sure everybody can hear me all right?
Yes.
Yes, we can.
Great. Perfect. So I am Chief Privacy Officer at Caveon, where I've been working for about 3 years, and I'm an attorney. I have to say the same thing you probably hear any attorney say when they speak in settings like this, which is, there's nothing I'm going to say to you today that is legal advice. If you have questions that require legal advice, you should definitely consult with counsel for your organization. So need to say that up front. Sorry for the annoying lawyer speak there. I've been working on privacy issues for about the past 8 years, certainly since well before the birth of GDPR. And I have my Certified Information Privacy Professional certification for privacy issues in the United States. And I have a strong interest in GDPR in the context of the certification business because the vast majority of Caveon's clients are in the certification business. And I've been working in testing and assessment on various issues in testing and assessment for about the past 10 years. And I have the pleasure of working with Rob Pryor, who will introduce himself.
Yeah, hi everyone, it's Rob here from PSI Services LLC. I work out of PSI's international offices, but I'm responsible for corporate compliance and security across all of PSI. I've been working in the certification sort of business for about 15 years, and then I made a switch to security in that specific place. And now I am working on GDPR, and I've been working on GDPR probably for the past 2 years with PSI, PSI's compliance program from that side of things. From PSI's perspective, that strategy goes across 20 plus US locations and 10 plus international locations. So there's an awful lot of privacy regulations and compliance issues going on within the certification space.
Thanks, Rob. And GDPR has been in effect now for about 4 months. And if you came to this session hoping to get GDPR 101 and get a broad overview of all the important components of GDPR, you're going to be disappointed because it is our sincere hope that you have already attended those webinars and been reading articles and doing the things that you need to be doing to bring your organizations at least closer to compliance with GDPR. So the idea behind this session is that we're going to focus on some key areas of GDPR and talk about the specific application of GDPR to the certification business in these areas. And the topics include data minimization, maintaining security while respecting privacy, honoring subject access rights, and criteria for selecting vendors. And just to keep things interesting, as you're getting up to speed with GDPR, we're going to point out several other laws that are coming online, both in the United States and abroad, that you're going to need to get to know if you do business around the world. So without further ado, we have a lot of ground to cover. We're going to move into these topics now. So, data minimization and privacy by design. These are two important concepts that are embedded in GDPR. Article 5 has a very important provision. This is Article 5 of GDPR that says personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. The idea here is you should only be collecting and processing data that you truly need to deliver the services that you are delivering to users that provide those data. And it's important not just to have this sort of lofty principle, but to be able to implement it. And another way that GDPR imposes that obligation is by requiring you, when you design new services and overhaul existing services, to use data protection by design and data protection by default. And you can read more about those obligations in Article 25. So here's the thing. You've been in business for a long time. You have your platforms, you have your delivery channels, you have your services. So what if you're not in the midst of starting a new program where you can just start from ground zero and say, oh, we are going to use privacy by design, and we are going to build or buy a platform that is going to ensure that all the data we collect is only what we need, and all the security features are built in, and all the privacy features and transparency and ability to respond to requests are all built in. What if you don't have the luxury of starting from that perspective? How do you comply with these data minimization requirements, specifically in the context of an online exam scheduling system, for example? And there's no person who's in a better position to answer that than Rob Pryor, who had to do precisely that at PSI. Rob, can you talk about that?
Yeah, sure, Marc. Basically, a lot of it boils down to what data you have today. Now, within the certification space, there's a lot of technology. So within that, what we tended to do was look at, well, how are we collecting that data from our systems perspective? So a lot of the restrictions were around the data minimization was, okay, how is that data collected? So within technologies, using software and so forth is to basically restrict what data we can collect. And then a lot of this ties back to the programs that you're delivering, or the certification and sort of programs that you use, is to ensure that you only collect what you need. Which again, it comes down to looking at contracts and so forth. So within our technology platforms, it's all about, okay, if you've got fields that you only need first name, ensuring that only the first name can be populated. So you're restricting the data collection. In addition to that, you also meet another obligation of GDPR, which is to do with accuracy of data. Okay, so obviously we only want to collect what we want, but we want to make sure that data that we are collecting from an exam scheduling perspective, that data is accurate. So every field within our technology is restricted with regards to the input, the formatting, validation of those fields. Okay, so every program may be different regarding what's required to deliver that certification, but it's ensuring the technology is there to restrict what is collected for each program and obviously how that data is populated. So we only hold the minimum amount of data and ensuring that data is accurate, so we don't end up with information that we don't need for those programs. Okay.
Now, Rob, you also have to collect fees, presumably as the test delivery vendor for many certification programs. Can you talk about compliance with the privacy by design concepts in GDPR and data minimization in the context of collecting fees for scheduling and rescheduling examinations?
Yeah, so with that sort of side of things, we go kind of through a 5-step principle for it, whether it's scheduling or the e-commerce approach. We've already touched on data privacy impact assessments. A lot of it is to do with the e-commerce pieces. Well, okay, what data do we need to collect for the e-commerce piece, and ensuring that we only store that appropriate data. Obviously with e-commerce, there's other compliance issues as well with regards to PCI. So with regards to people rescheduling or retaking, is what data do we need to collect for those individuals? So again, you restrict from your data set from a technology perspective to ensure that you only have what you need, or if you're using a third-party payment gateway, is ensuring that they only have the data that they need in order to process those rescheduling or cancellation effects from an exam perspective. Basically, the main means of that is ensuring that the end-to-end security of the system is secure. A lot of what we do is actually tokenization or ID related, so we don't have PII moving from one system to another and duplicating that data set along the supply chain or e-commerce process. So ensuring that we only have PII really in one central location, and then using other technology means, things like APIs and IDs, to reference that PII if we need to call a first name or a reference of a transaction that was occurred during the e-commerce scenario. In addition to that is ensuring that the visibility of what you are doing within that transaction is clear to the individual, the data subject. Okay, so they're fully aware in regards to their data being processed from either one system to another, whether that be e-commerce or for rescheduling, that they're aware that their data may either be passed or not passed, which is obviously the ideal from a GDPR or compliance perspective. Okay, so with a lot of these things in place, you're building a system which already has a lot of the privacy principles already in place for compliance with GDPR and other privacy standards throughout. Over to you, Marc.
Thanks, Rob. And right, I think it's important. I want to emphasize the point that you made there towards the end about telling users what you're doing. I mean, one of the most important principles of GDPR is transparency, right? And so If you're doing something with a user's data that you haven't told them about, or it's not, something you're contractually requiring of them in order to provide the service, or you haven't obtained consent, then you're probably doing something wrong unless you have a legitimate interest in that processing. And that's going to bring us to our next topic here, which is important, I know, to everyone in the certification space, and really, frankly, anyone involved in high stakes testing. That is maintaining security while respecting privacy. And as I've already, alluded to, there are only 6 lawful bases to process a user's personal data under GDPR. And I'm not going to go through all of them. I can tell you, though, that the one you should try and use as often as you can is through a contractual obligation with the user. But in order for you to be able to do that, you actually have to have a need to process the data in the way you want to process it in order to contractually obligate the user, to enable you to do that. So there's contract, and then there's consent. Now, consent is not the strongest form of a lawful basis, or not the strongest lawful basis, because under GDPR, if you have to require a user's consent to process their data, then that means the user can withdraw their consent to process that data. And that can put you in a quandary depending on the business application for that data. Go ahead, Rob.
Yeah, sorry, I was just going to add to the consent scenario within the certification world. GDPR also stipulates that consent has an option for freedom of choice. So within the certification market, if I don't provide consent, if that's your legal basis for processing their data, you're not providing a freedom of choice for them to do the exam. Okay, so if that, so from within our sort of industry perspective, is consent should try to be avoided pretty much at most costs. And as Mark said, you should be looking at the other legal means of which you can process the data.
And which everyone who has an IT certification program ought to be doing, which is having the user, the candidate for certification or the certified person be in an agreement with your organization that they are going to allow you to do certain things with their data in exchange for access to your certification program and ongoing certification. So the contractual basis is the strongest. Consent is a possibility, but now we're going to talk about legitimate interest, because that really comes into play when you're talking about protecting the security of your intellectual property, the integrity of your certification program. And legitimate interest is one way that you can justify taking certain actions and processing user data if it means you're going to attempt to protect intellectual property and prevent test fraud. But the key point with legitimate interest is it's not enough for you to say, for example, if you're questioned about why you processed a user's data in a particular way, well, we had a legitimate interest. You're actually required to go through a balancing test. And not just to go through a balancing test where you look at the interests of the organization versus the interests of the individuals in their own privacy. You have to weigh those competing interests, and this is key. You have to document the analysis. Now, I'm sharing with you a snippet of a legitimate interest assessment template that's offered by the United Kingdom's Information Commissioner's Office. And we've provided a link at the bottom of this page. And by the way, we'll make these slides available to you so you can obtain this resource. And this is a great way to conduct your legitimate interest analysis, particularly when it comes to security features of your certification program, if you are looking to use legitimate interests as a lawful basis for processing. So this form's available online. It's 4 pages. If you complete it, you will have documented your analysis, and that's just something that you need to hold on to. And Rob and I are going to get into talking about, well, what are some of the areas where you might have to perform this legitimate interest assessment? So Rob, let's talk about how the GDPR requirements have impacted the features of your delivery systems to prevent, detect, and respond to test security concerns, and how you've conducted the legitimate interest test.
Yeah, so as part of that, and as part of the slide, obviously biometrics, within our industry, it's probably a common point of thought as a security control is biometrics. Obviously, with the implementation or the rollout of GDPR, is that the considerations of using biometrics becomes significantly more difficult under the laws of GDPR. Biometrics or sort of genetic data, you can only process that data through two legal means. One is either the data subject provides consent or it's in the public interest. So from a certification delivery perspective, suddenly the use of biometrics as an ID verification technology or security control suddenly becomes a little bit more challenging, especially for obviously GDPR, those fall under there, and other international countries where they have different privacy laws within and around biometrics. So from PSI's perspective, the use of biometrics as an ID verification scenario suddenly becomes that little bit more concerning on how we can process that data, because as I mentioned earlier, the consent scenario. So if we were to say, right, yeah, we want to use facial recognition, for example, it's a very common now used term for biometrics for the ID of them doing their certification, they'd have to provide consent in an ideal situation. There could be arguments depending on the program you're delivering that there's a public interest, but the majority of the programs would have to get consent from the individual. As I said earlier, consent, you need to provide a freedom of choice. So if that's the only method of ID verification that you're providing to the data subject, then you are effectively in breach of GDPR, because you're not giving them any freedom of choice with their consent scenario, because you're basically saying, well, you've got to ID using your facial recognition in order to do the exam. That's just a one-way stop. Okay, so from our perspective, biometrics, is a great advocate for a security control, but you also need to provide an alternative, so the individual has a choice, okay, for ID verification. So from PSI's perspective, we're looking at putting biometrics in, but at the same point, obviously, still providing the traditional model of ID verification, as in looking at someone's passport or driving license or government ID, for example, as an alternative. So the candidate or the data subject has that freedom of choice. Okay.
Thanks, Rob. So what you're pointing out, I think, is important to make the distinction here that biometrics is in a special category under GDPR, and it's not enough to say you have a legitimate interest in fraud prevention to use biometrics because of that special category and the special rules that apply to biometrics. Am I understanding that correctly?
Yes, you are. And so if you were to apply the same scenario to CCTV footage, that is generally another well-known security control within the test center space, is yes, there is absolutely, you go through the same questionnaire for legitimate interest. There is absolutely a legitimate interest to apply that control within the test center. You are there to protect the IP, you're there to protect the interest of others, the integrity of the exam. And obviously CCTV is absolutely doing that, which meets all the grounds for legitimate interests as a security control.
Right, and just to point out the nuance in that, I think that's actually a perfect example. And I'm sure everyone's heard CCTV before, but just to be clear, we're talking about closed circuit television, video monitoring of live testing at a test center. And I think that's an excellent example, because think about if there was an incident, and so you've got a test center where you have numerous certification programs that have candidates testing in your test center at the same time. say you have 25 seats in your test center, and I am from, an IT certification program, and I have, I'm just sitting there minding my own business, taking the test, and there's someone next to me taking a graduate admissions test for some other program, right? And maybe that person for the graduate admissions test is doing something they shouldn't have done. There's an irregularity in testing, and that test sponsor for the graduate admissions program says, "Hey, PSI, we want to see your recording, right, of what's going on in the test center there." You're going to be sharing information that actually you're going to disclose the identities of other people who are testing in there who have nothing to do with that program. But again, I think that if you conduct a legitimate interest analysis, you can, make a strong case that, look, this is for purposes of fraud detection and prevention, and you're only going to share that type of video recording as part of an investigation of fraud, or if there is a suspicion of fraud. What do you think about that analysis?
Mark and Rod, this is Clyde. There was a question in the chat just asking whether that same scenario applies in remote proctoring, where the screen capture, where the recording is happening remotely instead of on premise. CCTV.
Yeah, go ahead.
Yeah, sorry. Yeah, I saw that question come up. Yeah, absolutely. Providing you're recording the exam, and that's, and it's in the integrity and for fraud prevention, you can apply the similar legitimate interest to that case. The only thing I would recommend in regards to that is ensuring that you do not record any basically ID verification as part of that. But as long as it's just the exam integrity part of it, then absolutely you could argue a legitimate interest case for that.
And do you see any distinction between CCTV that's recorded on site versus a remote proctoring scenario?
No, they're effectively the same control. The only difference is obviously CCTV could have many data subjects within it. Obviously, from a remote proctoring perspective, it's a one-to-one general relationship, but it's effectively the same control.
Thanks, Rob. I think we're going to move on to our next topic, and that area, by the way, of legitimate interests and fraud prevention and detection, in this business in particular, I think is an area that we could probably discuss for the entire hour, but we do want to cover the rest of the topics in our session. So another important aspect of GDPR is individual rights. And one of the most important individual rights is the right to control data. An individual, if you have an individual's personal data under GDPR, that individual has a right to know what you have, and to be able to make corrections to it, to be able to amend the information, and to request that you stop processing the information, and also, and this is a real challenging one, to delete the information. And this is the so-called right to be forgotten. And these are generally referred to as subject access rights. And how do you manage these subject access rights? Articles 13 and 14 of the GDPR, if you're someone who likes to look at the actual text, are the places you would look to see exactly what information you are obligated to provide individuals about their personal data. Now, in order to be able to respond to these subject access requests, you have to know where this data is and what you do with it, because you couldn't possibly tell the user what you have of theirs if you don't know what you collect, and you couldn't tell them how you're processing it or what you do with it if you don't know that yourself. So this data mapping is definitely something that should have been started months ago. And if you haven't done this in the context of your certification program, it is something that you absolutely need to do to be able to respond to these subject access requests. In addition, you have to have a policy in place for responding to these requests and a process for responding to the requests. So Rob, can you talk about how you have handled the subject access requests at PSI, particularly regarding policy, process, and systems and technology?
Yeah, so just the first one on the data mapping side, as Mark pointed out, that's an integral piece to knowing where your data is and what you're actually doing. We've already sort of discussed the legal basis or transparency part of data subjects with regards to processing. The data subject should already know what you're doing with all their data. Okay, so within any privacy statement that you are communicating to them, that should already be documented and forefront to the candidate. So we've already mentioned like CCTV, we've already mentioned that you might want to use it for marketing. The candidate should be fully aware that you're going to use that data for them. So data mapping is a pinpoint of that. Off the data mapping exercise, you should also do a DPIA. So you should identify any risks. If you've got any insecure connections, transactions that are going between one data set to another, they should all be done as part of a risk assessment. And you should be looking to resolve those, because obviously those areas are insecure for the data subject. So in regards to policy and process for handling requests, just to highlight, there is an SLA around this under GDPR, and it sits with the data controller. So typically, you need to identify who the data controller is. So if you're a processor of an examination for a client, generally the client will be acting as the data controller. But because you're the first, you could be the first for the data subject to contact you, you would need to pass that request to the data controller. The data controller has a lot more obligations with regards to ensuring that those requests, whether it be an information request or a request for deletion, are processed within the SLA, which is 30 days. Okay, so the 30 days sits with the data controller. So as part of PSI's process that we've enforced throughout the business, and we have a lot of technology, is typically any request that we get goes directly to either the data controller from first point, okay? Then there's a verification step. So if PSI is obviously the data controller or a client is the data controller, you need to do a verification. That's one of the most important steps. As we can all appreciate, anyone could email us, a contact or a data subject, a candidate, could email us and say, please remove your data. Okay, so the verification step is one of the most important that you must do. So from that, you will obviously have to verify against your own data sets to ensure that request is coming from an appropriate source. Once you've done that, typically what we will do is actually provide a list to the data controller of all the data that we hold, okay, on that individual. So whether that be email address, first name, last name, okay, it could be that we've got tickets about them because we've had to deal with support requests. It could be transactions. It could be some information with regards to results and those kind of things. So we'll pile a list of data fields. We won't obviously send that data, but we'll communicate those data fields to the data controller. Okay, so depending on what the request was, generally we'll honor whatever was in the request. So if the data subject says, oh, please just delete my remote proctoring video. Okay, so then we'll just honor that request with the data controller to remove that remote proctoring video. Okay, generally the data controller should validate what they want to be removed or provided. Okay, because they might have other legal means for processing or retention of that data. So it's not a case of the data subject just saying, please remove all my data. The data controller may have a layer on top of that to say, no, we need to retain this because we have a legal basis to keep that information, okay, going forward. So, from that aspect, sorry. Go, Mark.
Rob, can I just add on there, that example you gave is actually a perfect example of one where I would expect, if you're a certification organization, you're not just going to automatically agree to delete a remote proctoring video of a testing session. You know, you might have a question about that testing session. Did the session lead to you know, the candidate passing the test or failing the test, and are there any questions about that test session? So that's the type of thing that I would expect you would want to have in your agreement with the candidate, that you're going to keep those recordings for a specified period of time, and that you have the right to keep them for a specified period of time to investigate any potential irregularity in the test administration. So just, I mean, not to go too far off, Rob, but I just think that's a great example where just because the user comes forward and makes this request doesn't mean that it's going to be granted.
Yeah, and there's other scenarios that fall into that bracket as well within our world. You know, things like number of retakes. So if there's a policy in place with this part of the certification program where a candidate, you know, can't retake a test after, say, 2 years, but then they submit a request to say, please remove all my data, you know, and you remove all their data, could they submit another request to take the exam under those 2-year periods? So obviously, again, you know, the controller will have to mandate that, no, that you'd have to retain some form of data to ensure that that candidate could not register again and break the testing rules for that certification program.
And Rob, another question on that dimension is for candidates who were successful, we actually had a case of this, who were successful in earning the certification and then subsequently requested their record deleted. By definition, that means they're no longer certified because we're no longer holding their record. So there's, you know, I guess does that interact with the freedom of choice piece, right? Because they can't say delete my record and yet still keep me on the roster. If they're saying delete it, it's basically delete my record, strike me from the rolls. And
yeah, exactly. And
you don't get a refund, right? It's not like, oh, well, I changed my mind. You know, refund me my money and take me off your list, right? It's just, you know, clarify. Is that appropriate to just clarify that this is the implication? You will no longer
yeah, they're absolutely, and the certification body or owner would need to determine what those rules are, because you're quite right. You know, or is it a case that they've been issued that certificate, so they still have the qualification, you know, but then the central record is removed. You know, as I say, the certification body would need to define what their policy is in under GDPR with regards to retaining that record for that individual.
Everyone else has left the call. Everyone else has left the call. Goodbye.
Hello?
Don't worry, everyone
Hello?
is still here. I don't know why that happened.
Okay. Someone requested to be deleted from the call. So Rob, we have another question here about the removal of or the production of records that relate to financial transactions and certification volume reports. Can you speak to those, and then also get to these other issues of you know,
record and backup,
actually keeping records of people who request to be deleted, and then how you deal with that on backup systems?
Yeah. So with regards to the financial, you'll have other legal grounds to retain those financial transactions outside of GDPR. Okay. So depending on your government organizations, you may have to retain financial records for up to 7 years. So again, as part of any, you know, outside of really GDPR, but a part of any information security standard, you know, whether that be a SOC or an ISO 27001, you should already document those information assets and the legal retention periods for them, because obviously they, you know, they have to work together. So if you've got, you know, from a financial institute perspective, you need to retain, from an audit perspective, all your financial records for 7 years. That's going to overwrite the individual's right to delete those records. Okay, so you clearly cannot delete that financial information, and you must retain it for whatever that retention period is. Okay, with regards to exam results and whether you're creating additional reports and those kind of things, providing those reports don't have any PII within them, actually you can use that data. Okay, remember GDPR is all around PII. So if you're creating statistical analysis of those reports, based off exam criteria, providing you're not identifying any individuals within those reports, or any PII, then absolutely you can create that data set. Okay, the only thing I would say is that you would should be communicating that as part of your privacy policy, that you might use it for scientific research or and those kind of things in regards to the exam. So you're being transparent with the data subject, but you should obviously be able to keep those reports, providing you don't have any PII. Where those reports, obviously, you're going to have a load of PII, the data subject's information, then absolutely they would have a right for you to delete that information. Okay, so hopefully that answers those two questions. With regards to the record, okay, you have a right to maintain an audit record for all of these requests. Okay, so within there, as soon as you get that request, whether it be from the data controller or directly, okay, you have a record to make sure you can audit that you have processed that request. Okay, because if you were to get investigated by any one number of the supervisory authorities, that's the first thing they're going to want to look at is, here's your data subject access request, have you honored those requests? So you need to maintain some form of audit record. The principle of retaining that audit record, and I touched on it earlier, is ensuring that typically a ticketing system would be ideal, is do not include any additional PII within that audit record. Yes, you've got the initial request, but communicate the processing or the audit trail for it using data fields. Okay, so rather than you putting and copying in, yeah, we've got their email address at mail.mail.com, you just say, yeah, we have their email field within X systems or X places. Okay, so that audit trail doesn't retain or actually have any additional PII for that individual. Okay, with regards to backup systems, you do not have to remove it from backup systems, okay, as long as those systems, are only held within a reasonable time. We've already discussed that you should only hold data for, the minimum amount of period, or for, for as long as necessary to carry out the processing. That applies to backup systems. So if your backup schedule is, say, 10 years, I would argue under GDPR you'd be non-compliant. So your backup system, you'd need to review that and ensure that it is compliant with GDPR policies. Ideally, once you've processed that request, it should propagate throughout your backup system within a timely fashion, okay, in order for that request to be fully processed. However, if you do have to restore from a backup system in the event of, an incident or something occurring within your organization, and this is where the audit trail comes in, you would need to process those data subject access requests once again, because obviously you're restoring that data. I'd also like to add that once you have removed that data from the request and completed it, the data subject does have no right for them to say you must restore it as well. Okay, so once they've done the request and you've processed it, if you get a second request, say, please restore my data, you do not have to obligate that request. Okay.
Thanks, Rob. There's one other piece that I think may be of interest to this particular audience, and that is the European Court of Justice decision in the Irish case on exam scripts. And I just want to set it up that essentially, if you require an open form response, like a constructed response or an essay in any of your exams, you may be required to actually turn over those constructed response, data in response to a request for personal data. Do you want to just, in 30 seconds or less, just mention what happened in that case, Rob?
Yeah, sure. And that's just one case. There has been others. What has been determined is that if I'm writing a response, as the candidate to a question, is the court basically determined that because I wrote it, that data belongs to me. Okay, in addition to that, what they also clarified is if there's any markup to that data. So for example, if it is an essay question and you have someone that's going to mark that essay writing skill, is that markup is about me. So it was deemed within the court that that is also my PII data. Okay, so from the ruling of the Court of Justice, and it's happened, I think, several times now, is as part of a information request, is the individual could request for those written responses, and that's the key criteria of the ruling within the courts, is it's the written responses. Okay, so it's the personal response that someone is applying to those questions. It's not your standard MCQ scenarios where the responses are obviously static or fixed.
Thanks, Rob. So for those of you considering innovative testing designs, if you're in Europe, you may be better off with a multiple choice format unless you want to start having to produce constructed response items from your test takers. So we're going to keep moving here. The penultimate topic we have today is criteria for selecting vendors as processors. And I was sort of joking with Rob before we started this call, but many of the country's greatest processors, particularly cloud platforms and the like, probably have certification programs and are probably represented on this call. But we have a number of tips here that are pretty high level for what you want to look at when you're selecting vendors as processors, but also keep in mind that if you are, as a controller, you're not only responsible for the compliance of your processors, but you are also responsible for the compliance of the sub-processors, so the processors for the processors. So these criteria apply for all of them. If you are entering a major change in the way you do things with your user data, you must conduct a data protection impact assessment, and that is going to require vendor participation. Now, even if you're not undertaking a major change, if you're hiring a vendor, for example, to carry on an existing program without changing much in the way of specs, you would still want to have the vendor complete a data practices questionnaire. You would want to request the SOC 2 audit report. That's the SOC, Security of Controls audit report. And it would be great if any vendors you're using have ISO certifications. And as I write here, they're not mandatory, but they certainly are a big plus if your vendor has the ISO certifications. Rob, any comments before we move on to this next group of bullets?
No, they're absolutely good criteria. The only thing I would say is you need to do it retrospective as well. Is don't just say, right, for GDPR compliant, we're going to put in this vendor process. Is you need to retrospectively evaluate your current vendors with their GDPR compliance, especially the sub-processes and the sub-processes that they may use in order to provide the products and services to you.
And that's an excellent point, Rob. Thank you for mentioning that. That's right. It can't just be looking forward. So if you're just getting into the groove of GDPR compliance, these are processes you should be undertaking for your existing vendors, and that's an excellent point. And really, this may seem obvious, but you need to have a commitment from your vendors to comply with GDPR. I've had customers tell me that they have, spoken to vendors and said, we need you to be GDPR compliant, and the vendors have essentially said, we're not doing it. And I say, if you speak to a vendor that's telling you we're not doing it, and you have business in Europe, I think it's time for a new vendor, or certainly time to be talking to different vendors. Privacy Shield is something that's gotten a lot of airtime, but it's important to point out that Privacy Shield, which would only apply to US-based for-profit company, is not an essential component of GDPR compliance, and a vendor having the Privacy Shield does not mean that they are GDPR compliant. The Privacy Shield is outdated. It was put into effect prior to the passage of GDPR, and it hasn't it does not establish GDPR compliance. Having said that, if you have a vendor that has Privacy Shield, it's a plus. It shows that they have some understanding of privacy issues, but if they are telling you this means they are GDPR compliant, then you might want to run for the hills. As Rob and I have already mentioned, you need the details of sub-processors as well as the processors. And you can have a contract that has all the data processing terms already in it, but if you're already under a contract with your vendors, you definitely want to look for a data processing agreement that includes the standard contractual clauses for processors transferring data out of the EU, and also specifically speaks to GDPR compliance. And there are no contractual clauses at this point that you can just rip off of a website and attach to your contract that magically make you GDPR compliant. So it's not quite as simple as it used to be when the EU was simply under the directive. These last 3 points are really important. You should know that your vendors have cyber coverage and require a certificate of insurance. You absolutely need to be requiring indemnification. So it's not enough just for the vendors to have insurance. And by the way, you should have your own cyber coverage as well, if that isn't obvious. But you also want the indemnification piece, which is like belt and suspenders. And you want to make sure that your vendors are indemnifying you not only for their failures, but for the failures of their sub-processors. And then lastly, you want to require the right to conduct audits, to ensure that these vendors are doing what they tell you they're going to do. Any comments on those, Rob, before we move forward?
No, as I say, the audit right applies both ways, as in for your vendors, you have the right to audit them and ensure that their sub-processors are also compliant. But in addition to that, under GDPR, is the data controller has an audit right upon its processors, okay, which is a key component that's come in, and just from an experience perspective, is generally something that is always negotiated, but GDPR has basically said it's a bit more of a black and white scenario, that the data controller has that audit right for all its processors and sub-processors.
Thanks, Rob. Now, we only have about 5 minutes left, and we probably have more than 5 minutes of content, but I'm going to try and breeze through this here. And again, you'll be able to get the slides. There was a ballot initiative underway in California for a Consumer Privacy Act, and then in the 11th hour, all of a sudden, the California legislature said, oh, you know what, we're just going to pass a law. And this is the law that came out of it, the California Consumer Privacy Act of 2018. It does not apply to nonprofits. So if you're a nonprofit, this is one less law you need to know. But if you're a for-profit company with $25 million in annual revenue, or a company of any size with at least with personal data on at least 50,000 people, or where you collect more than half your revenue from the sale of personal data, this law applies. Now, without getting into the details of it, I'll just say it is a variation on GDPR, and it's something that if the law applies to you, you're going to need to make sure you're familiar with. It's probably going to be modified several more times before it takes effect on January 1st of 2020. We also have, one of the world's largest economies, Brazil. They just passed their own data protection law, and the LGPD. Those are just the letters that align with the Portuguese words for their data protection law. Again, it's quite similar to GDPR. And there are some differences. If you do business in Brazil, you need to know about this law. And then let's not forget about yet another law waiting in the wings from the European Union, which is this e-privacy regulation, which is really directed at electronic communications, digital advertising, and marketing. Now, this is not law yet, but it looks like it's probably going to be adopted in 2019. There are a lot of big tech companies from the United States that are lobbying hard against this and to soften it because of the way it affects, for example, messenger services and the data that can be pulled out of messenger services for advertising. And there's stringent regulations on cookies. And this law is going to take priority over GDPR on issues that are addressed in both the e-privacy regulation and GDPR. So it's another layer of complexity that you need to understand. And then I'm going to turn to Rob to talk about data residency laws. We've only identified 2 countries here, but these laws are becoming more prominent in countries throughout the world. Rob, can you just talk for a minute about how these data residency laws work and how they can impact our businesses?
Yeah, so this is really kind of the next step on, if we're looking maybe, probably 4 or 5 years down the line, is that data residency is probably going to be the next sort of talk about thing, and that's regards to the PII data. So it remaining onshore within the country that it was collected. Okay, so Russia already has their own, Vietnam has their own. There's generally a lot of talk, even within the European Union. Germany's one of them that are talking about this at the moment, with regards to, even with GDPR in place, he's saying that no, if you're collecting data about our residents or our individuals, that data has to reside within the country itself. Obviously, from a technology standpoint, that provides, and from a global certification delivery perspective, it creates an awful lot of challenges in order to meet those obligations. So this is just kind of a little another, stepping stone, but could have huge impact within our industry.
Thanks, Rob. And we've basically come to the end of our presentation. One thing we wanted to do, though, was give you some resources. Here we've given you the links to the Information Commissioner's Office from the UK for the guide to the GDPR, which is arguably the most user-friendly, informative, helpful resource for getting to know GDPR. There are templates, there are tools, there are assessment devices. It's a fantastic website. DLA Piper is an international law firm. This is not an endorsement of DLA Piper by any stretch of the imagination, but I will just say that their data protection website covers international laws and provides a wealth of information about all kinds of data protection and privacy laws in effect around the world, and it's a great resource. And lastly, the International Association of Privacy Professionals, which is the certifying body that sponsors my privacy certification and many others, has a great website, and they also have a listserv for members. Membership isn't that expensive, and if you're a member, you can join the listserv, and I think it's a real helpful tool for connecting with privacy professionals throughout the world on various issues and questions of interest. And then lastly, if you have questions after this session, which I know we're right up on the hour, please don't hesitate to reach out to Rob or me by email, and either one of us will do our best to help you however we can. And it's been a pleasure talking to you. Thank you for the opportunity.
Thank you, everyone.
Thank you, Mark. Thank you, Robert. Does anyone still on the call have any questions before we wrap up? I will take that everyone is forever holding their peace. But if you would like to email them one off, there are their emails, and we will have everything posted shortly. Thank you, everyone, for coming.